Good afternoon. I am calling this adoption hearing to order at 1:03 p.m. For the record, I am Mark Voloshin, Deputy Secretary of State for Elections, and I will be conducting this regulations adoption hearing today. First and foremost, if you are interested in participating in this meeting, you can call 1-888-475-4499 and then provide the meeting ID number, which is 846-0905-4473. Again, that is 1-888-475-4499 with a meeting ID number of 846-0905-4473. When prompted for a participant ID, please press pound. Then press star 9 to take your place in the queue. This is the adoption hearing for the Secretary of State Elections Division's proposed regulations with the LCB file numbers R091-23RP1, R092-23P, R093-23P, R094-23P, R106-23P, and R107-23P. Agenda item number 2. Public comment on matters not on the agenda. Comments will be limited to 2 minutes per person. We'll start here in Carson City and then go to Las Vegas, then go to the phones. Is anyone interested in providing public comment about a matter not on the agenda? Starting here in Carson City, I see none. In Las Vegas, I see none. Broadcasting, can you check the phones, please?
Yes, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue. There are no callers choosing to participate at this time.
Thank you. At this time, then, we will close the general public comment and move on to the regulations. It is noted for the record that the regulations will be addressed one at a time in numerical order. Public comment will be taken in the same order, and public comment on a particular regulation will be closed before moving on to the next regulation. Before public comment is opened on each regulation, I will read into the record a summary of the proposed changes. I will also include a list of the suggested changes that we will be incorporating to the final text prior to the meeting of the Legislative Commission later this month on February 26th at 10 a.m., which I will double check. Before we begin, I want to clarify a few things. Our discussion today during this adoption hearing will be focused on the proposed regulations listed in the agenda. We should not discuss changing statutes, which are, of course, created by the legislature. This regulatory process will not alter any existing laws. Regulations, after all, cannot make something illegal that is otherwise legal, nor make something legal that is otherwise illegal. These regulations in this regulatory review are intended to update our regulations based on experiences from the previous election cycle and county clerk and registrar input with the expressed intent of increasing security and transparency. This adoption hearing is not the end of the regulatory process. Following the completion of this adoption hearing today, the next step is the Legislative Commission later this month on February 26th at 2 p.m. Furthermore, we are here today because of two specific statutes, NRS 293.124 and NRS 293.247. NRS 293.124 establishes the Secretary of State as the Chief Officer of Elections. It states, and I quote, in part, the Secretary of State shall serve as the Chief Officer of Elections for the state. As Chief Officer, the Secretary of State is responsible for the execution and enforcement of the provisions of Title 24 of NRS and all other provisions of state and federal law relating to elections in the state. The Secretary of State shall adopt such regulations as are necessary to carry out the provisions of this section. End quote. NRS 293.247 states, the Secretary of State shall adopt regulations not inconsistent with the election laws of this state for the conduct of primary, presidential preference primary, general, special, and district elections in all cities and counties. End quote. There's a lot more to it, but these provisions are what have brought us here together today. If there are general questions about elections procedures, I'll be able to discuss them today, as long as they relate to the proposed regulations. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at nvelect@sos.nv.gov. As of this morning, the Secretary of State has received public comment from multiple organizations and individuals. The written public comment received by the Secretary of State's office is hereby submitted into the record. A workshop was held to solicit public comment on February 2nd of 2024. Since then, the Secretary of State has continued to receive written feedback relating to the proposed regulations that we will discuss today. I will address some, but not every one of the proposed suggestions and comments received. Some of the suggestions have been incorporated into these proposed regulations. In those cases, the amended text will be described, but the final version of the text will be available prior to the meeting of the Legislative Commission later this month on February 26th at 2 p.m. Other suggestions will require further research and analysis over the coming months, but may be considered for separate regulations following the conclusion of the 2024 election cycle. Some suggestions conflicted with existing statutes or exceeded the scope of these regulations were not considered. Finally, the Secretary of State had a number of requirements to weigh in the consideration of the provided public comments, specifically related to increasing security and transparency. While many of these proposed regulations create additional requirements for the clerks, registrars, and Secretary of State staff, it's important to recognize that the work required by our state and county election officials has increased in the last few years, and there are no good metrics upon which to base future requirements. Therefore, we do not have a clear precedent to look to for future election cycles. Altering these proposed regulations to make them vastly more stringent or to greatly increase requirements could make them impossible to accomplish. Therefore, in many cases, we are moving forward with measured, reasonable improvements, but with an eye on future modifications that will be based on lessons learned during the upcoming election cycle. Ongoing election cycle, really. A few administrative notes. I will be taking notes while you are providing comment. If you see me looking down, it is because I am typing. Once I get to the public comment, I will first take public comment here in Carson City, then in Las Vegas, and finally on the phones. To be clear, the meeting is a discussion. If you ask a question, as long as it is related to the agenda item, I will be able to answer it. Once we are complete here today, my team and I will discuss and analyze the final suggestions, bringing them to the county clerks for input if necessary, before ultimately making any final recommendations to the Secretary before the meeting of the Legislative Commission. Finally, I understand that discussions about elections can get intense, and I'm excited about talking with you today, but I must ask that each of you treat each other with dignity and respect. Your fellow Americans in the room and listening in today may have different opinions, but they are worthy of your courtesy. Agenda item 4. The adoption hearing regarding proposed regulation R091-23RP1. Okay. Existing law requires the county clerk, upon receiving certain petitions containing signatures which are required to be verified, to determine the total number of signatures on the petition, tally the number of signatures for each petition district contained fully or partially within the county, and forward that information to the Secretary of State. Section 2 of this regulation provides that when a county clerk is determining and tallying the total number of signatures, the county clerk must count each signature on the petition, including any signature that has been crossed out. Existing law requires the county clerk to verify a certain number of, or percentage of signatures on a petition, and provides that the county clerk may use the signatures contained in the file of applications to register to vote to verify signatures. For a person who signed a petition and who registered to vote by computer and signed his or her application to register to vote using a digital or electronic signature, existing law authorizes the Secretary of State to establish other methods for a county clerk to verify such a person's signature. Section 3 of this regulation authorizes the county clerk to check the signature of such a person who signed the petition against all other signatures of the person in the records of the county clerk. Existing law authorizes a person to submit a written request to a county clerk to remove his or her name from a petition for initiative or referendum, or petition to recall a public officer. Sections 4 and 5 of this regulation authorize the county clerk to accept such a written request by electronic mail if the request is submitted on the form prescribed by the Secretary of State. Now, for this regulation, one thing I do want to address, there was some public comment provided during the workshop as well as via email. So I'm going to clarify, first and foremost, that this does not allow somebody to, it doesn't force keeping somebody's name on a petition. There is an appropriate time in the process, as defined by statute, when the individual's name would be removed from the list, and that, again, continues to exist. This regulation simply identifies that for the purposes of the raw count, that initial count, that those individuals' names would be counted as well, which is, again, which lines up with the statutes. Other feedback that we received relating to this petition. I do want to clarify that this does apply to both clerks and registrars as well. And at this time, I will open public comment on the proposed regulation. This time, is there anybody interested in proposing Comment on proposed regulation R092-23, starting here in Carson, in Las Vegas. And broadcast, could you check the phones, please?
If you would like to provide public comment on R091-23 RP1, please press star 9 now to take your place in the queue.
Good afternoon. Oscar Williams, OSCAR, WILLIAMS. I'm against this regulation. I spoke against it in the workshop. I'd like to ask a couple of quick questions, though, and my comments are very brief on this one. But let me ask you a couple of questions. Why is this regulation needed, and who has asked for it?
Mr. Williams, Mark Voloshin, thank you for the question. So your first question is, why is this regulation being proposed and who asked for it? It relates, again, specifically to certain petitions, including recall petitions. As you may be aware, actually, I suspect you probably are, there are a number of recall petitions that have been proposed, discussed, and have gone through various phases of that process. One of the processes that it relates specifically to recall petitions deals with signatures and the raw count as well as the verification. And as we've gone through those processes, and let me back up just to clarify. So there, for those that aren't aware, there were 2 recall petitions that were drafted relating to Incline Village in Washoe. There were 3 that were discussed in Esmeralda County. There was another in Palomino Valley, also in Washoe County. So again, not a small number of petitions, and that's not including the initiative or referendums that we have across the state also. So as these questions came up about, how to, details on the raw count, essentially, the goal, Mr. Williams, is really to make sure that these discussions that we have, that we clarify, not just via email or a phone call, but really the goal is again, not to make just masses of regulations, but to make smart regulations. And as you know, the regulations cannot conflict with statute. So essentially they are an opportunity to provide clarity as to how these...
Can I interrupt for a second? Mark, may I please interrupt on that?
Sure.
And that's a great summation. I appreciate that. But as far as I know, the system in place works. It's not broken. It doesn't need fixing. And this regulation is a major departure from the status quo. All right, it's occurring in an election cycle. You're moving the goalpost on this, and of course we have an abortion rights bill, ballot initiative that's been announced. So if you want to turn Nevada or give a greater opportunity for Nevada to be turned into some sort of a destination or an abortion attraction, because you're allowing everybody to the anything goes policy of any signature on the history, a variation of it, so on and so forth. I have a problem with that. I don't think that's the right way to go. I think it's unconstitutional, and there's a number of problems with it. When I use my signature on authoritative documents, I use my very one singular, hopefully bulletproof signature that is hard to forge. Other things that I use a signature thing at the grocery store. You can't even recognize it. So, we have variations of signature, and maybe I paid a parking ticket and I signed it one way and spelled my name a different way, or maybe I just did a really lousy signature. It doesn't look like mine. That doesn't mean that that's the best policy that when it comes to voting and ballot initiatives and things like that we should use any variation of anybody's signature in the history of a database. That's called mission creep or signature creep. It's another form of like 3-card Monte. Let's just keep, turning over the cups of signatures till we find the one that fits, so we can get our legislation passed or our ballot initiative or our recall petition. We historically have had very stringent signature verification requirements on these kinds of things, and you guys are flipping it 180 with this regulation. And you're doing it by administrative fiat. This is legislative work. It needs to be reserved for the legislature. That's my time. That's all I got to say. Thank you.
Thank you for your comments, Mr. Williams. I do feel the need to clarify for the record that this proposed regulation was not related to any existing or currently fielded or submitted or ongoing statewide petition. The result of this petition is a direct result of the discussions relating to the recalls petitions that have been identified over the years. And again, is certainly not in conflict with statutes, but I do appreciate your input.
There are no other callers choosing to testify at this time.
Thank you, Broadcasting. Okay, hearing no further comments, public comment on proposed regulation R091-23 is closed. And hearing no further public comment, regulation LCB file number R091-23 is adopted and will move forward to the Legislative Commission. And I'll start the adoption hearing regarding proposed regulation R092-23. Existing law requires an independent candidate for partisan office to file with the appropriate filing officer a copy of the petition of candidacy that he or she intends to subsequently circulate for signatures. Existing law further requires that such a petition of candidacy may state the principle, if any, which the person represents. This regulation provides that any such statement of principle must be 200 words or less and appear on each signature page of the petition. At this time, again, first of all, let me address comments relating to this petition. We're really just more asking for clarification than anything, and there are no proposed changes to the proposed regulation. So at this time, I will open public comment on proposed regulation R092-23P, first here in Carson. There's no one. Second in Las Vegas. And then third on the broadcasting. Can you check the phones, please?
Yes, Chair. If you would like to provide public comment on R092-23P, please press star 9 now to take your place in the queue. There are no callers choosing to participate at this time.
Thank you, Broadcasting. Hearing no public comment, we will close public comment on proposed regulation R092-23P. And regulation LCB file number R092-23P is adopted and will move forward to the Legislative Commission. Okay, we will now begin the adoption hearing regarding proposed regulation R093-23P. Existing law provides that a candidate, person, organization, committee, political party, or nonprofit corporation that violates certain provisions of the Nevada revised statutes relating to campaign finance is subject to certain civil penalties. Existing law further authorizes the Secretary of State to waive such a penalty for good cause shown. Existing regulations set forth the circumstances that constitute good cause for waiving such a civil penalty. Section 1 of this regulation eliminates these provisions from the Nevada Administrative Code. Existing law provides that if a Secretary of State waives a civil penalty for good cause, the Secretary of State is required to 1. Create a record which sets forth the civil penalty has been waived and describes the circumstances that constitute the good cause shown, and 2. Ensure that such a record is available for review by the general public. Section 1 requires any such record to be posted on the internet website of the Office of the Secretary of State. The change to this one that I want to read into the record is that instead of requiring that we post every record on the website of the Secretary of State, it will require that the details be consolidated into a quarterly report to be published not later than 15 days after the end of each quarter. The feedback that we received relating to proposed regulation R093, again, generally related to a request to try to make more specifics and create a more robust list prior to removing the other the currently existing examples. But again, when we looked at doing that, and given the amount of time and frankly the amount of legal review that it was going to require, it grew pretty voluminous, I will say. Numerous pages, a lot of situations, and that was just purely based on looking at the many scenarios that had come up over the years relating back to legitimate and validated waiver requests relating to these financial records. So to that end, again, the one change that we have identified by making it a public report so that we can make sure that the transparency continues and there's awareness as to why individuals are getting these waivers. Again, this is basically seen as a happy medium so that we can provide, again, continued transparency while allowing flexibility given numerous circumstances. At this time, we will open public comment on proposed regulation R093, starting here in Carson City. There are none. In Las Vegas, none. Broadcasting, can you check the phones, please?
If you would like to provide public comment on R093-23P, please press star 9 now to take your place in the queue. There are no callers choosing to participate at this time.
Thank you, Broadcasting. Hearing no further public comment, regulation LCB file number R093-23P is adopted with the changes as mentioned on the record and will move forward to the Legislative Commission. We'll now open the adoption hearing regarding proposed regulation R094-23P. Existing law provides that any registered voter who is unable to mark a ballot or use a voting device without assistance by reason of a physical disability or an inability to read or write English is entitled to certain assistance, which may not be denied or impaired when the need for said assistance is known to the election board or any member thereof. This regulation authorizes a registered voter with a physical disability to use a mobile device to access interpretive services to assist him or her in casting a vote in an election. This regulation also prohibits a mobile device used to access interpretive services from being used for any other purpose while voting or in the manner prohibited to the general public while observing voting. There is one additional change to this proposed regulation as well based on the feedback received. Specifically, again, when you look at the proposed text on the first page of R094-23, the second subsection of section 1 states a registered voter who uses a mobile device pursuant to subsection 1 shall not use the device for any purpose other than to access interpretive services or in a manner prohibited by NRS 293-274, which of course is the statute relating to ballot selfies. That specific subsection 2, we received significant amounts of feedback about that being too limiting, and in part because of the numerous voters across our state who use or receive digital sample ballots and want to use those electronic or digital sample ballots while they're at the polls. That proposed regulation would have prevented them from doing so. So that subsection 2 is going to be struck from the proposed regulation. Okay, this time I will open public comment on proposed regulation R094-23P. Starting here in Carson City, none. Going to Las Vegas. And Broadcasting, can you check the phones, please?
If you would like to provide public comment on R094-23P, please press star 9 now to take your place in the queue.
Good afternoon, Oscar Williams again. Let me think about this for a second. I think this is another case where the Secretary of State's going a little far on writing legislation. Why is this not administrative overreach, Mark? They're given extending rights, doing things that are just, I appreciate where it comes from, but at a point it goes too far. You're welcome to respond to that question. Do you understand the question?
I'm sorry, Mr. Williams. Did you have a question?
Why is this not administrative overreach? I really think that this is you're writing law, you're writing legislation, you're not writing regulation of it. I mean, in general, let's just step back for a second. The law should state, if you're going to do this, and I don't agree with this, but if you're going to make the law should state that smartphones are allowed, and must be monitored by the election board, right? That's basically where this is going. But the Secretary of State, the Secretary of State may then clarify what that use is allowed and how the board monitors such use. How should a poll worker react to an improper use? Those would be regulations, but you're not doing that here. You're actually writing the law, okay? I don't think that that's appropriate. Let me move on. So let's say you're deaf or you're of limited English proficiency, LEP. You come to the polling location, how do they request for voter assistance and demand or require use of their electronic device? That's, again, an area of regulation that's not stated. How does a deaf person communicate what they want to the average poll worker? Do they have it written down? Here's what I want. Are they going to bring in their cell phone and have Siri talk to them? I mean, it's a legitimate question, though. And again, to the limited English proficiency, if they don't speak English, how are they going to request what they want if the poll worker doesn't know their language? How does that communication go? So does the interpretive services allowed on the phone occur at that point when they're checking in, or is it when they're in the voting booth? That's an important distinction to make. Can you answer that?
Mr. Williams, Mark Velosh for the record. I can. Thank you for your comments. So to make sure I cover them, your question, one of them at first was a question about overreach. Again, I do want to reassure you that these, again, have undergone legal review to ensure that we are not conflicting with or creating anything that would conflict with statutes. Excuse me. In regards to somebody with a low English proficiency, how do they communicate? Again, there's a number of different ways individuals with low English proficiency are able to communicate. Some polling locations, depending on what county you're in, have interpreters at those polling locations during certain hours to facilitate those sorts of discussions, to make sure that those American citizens are able to have their questions answered about the voting process. Questions about your concern about interpretive services and how would an individual convey that as well. I think part of it too, right, goes back to maybe a slight misunderstanding that poll workers aren't to scrutinize and evaluate for rightness the motions of an individual who's in the polling booth. Your question, I think, suggests that if an individual pulled out a phone like is acceptable currently in a number of our counties with a digital sample ballot and was reviewing that sample ballot, you make it sound as though that the poll workers should somehow be monitoring that process or stopping them, which is not the case.
No. Let me clarify. That is a good point. I think we should get to that topic, but I think we strayed from what I was asking about. I'm asking, you're allowed to access your electronic device in the privacy of your poll booth. That's the law. Is that correct? Did I get that correctly?
I'm sorry, can you say that again? You're asking what the law states in regards to ADA compliance?
My understanding is not specifically ADA compliance, because we're talking about limited English proficiency and some other things, but basically you have certain privileged voters are extended the right or the ability to access their own electronic device within the privacy of the polling booth. That's an accurate statement under the law.
The individuals, as identified in this regulation, would be able to use their phones to be able to understand their ballot, and so that they could cast a ballot. Yes, and I think you refer to them as privileged. I would simply argue that they're afforded the same rights and opportunities that every other American citizen is.
Yeah, we'll get to that, and maybe some other speakers will talk to that. But I guess my question is not being clear enough. Then, so look, they come into the polling location. They may need to use that electronic device when they're checking in. Are they allowed to do that? Is that written in the statute or the regulation that you have? I don't think it is, but maybe it should be. I mean, that's why it's like, well, what do they do when they walk in? How do they request their use of their electronic device? Now, it's great that you have translators in some locations. let's jump ahead to that. You don't even need to answer that question, Mark, because I think I'm taking too much time there. Let me move on to some points. Let me go to deaf voters. So let's see, Section 1.1, services may include American Sign Language. Okay, that's nice. Of course, we don't know how many deaf voters there are, and we certainly don't know how many deaf voters who are illiterate on sign language. How many actually use sign language and know sign language? Because, you know, a lot of them know how to read, and we provide instructions in print. And, of course, a lot of them know how to read lips. So the dubious extension of what's a euphemistic electronic device, and let's talk about that for a minute. My idea of an electronic device for a deaf person is a hearing aid, okay? Now, we got cell phones now, but now we have cell phones that have cameras and recording devices and internet connections, and they're supercomputers. They're not just it's not just an electronic device. It's got AI assist now. In fact, I was just looking at an advertisement for a Samsung S24 with Chat Assist AI. So you can text in whatever you want, and it'll spit out the translated text. It's brilliant, but we get into, I think, an issue, or part of my concern here is enlargements of certain rights for certain voters and not other voters, right? Whether they got a disability or not, because the whole thing about disability, I mean, deaf people fine, but you haven't proven the need for the deaf people. I mean, and they've got alternative needs. And indeed, with limited English proficiency, do you have any statistics on them, sir? Can you justify it from a statistical basis? Because I do have some stats, if you don't. Do you?
If you're looking for a specific number of registered voters that are low English proficiency, I do not have that, no.
Okay. In 2021, I believe it was Assembly Bill 246, they came up with a little slide for the present this bill, and based on ACS data of 2015 to 2019 5-year estimates, okay? This is from 2021, and I'll be happy to provide this to you by email, Mark. But it identifies in Washoe County 2 major groups that are of limited English proficiency. It is Hispanic, at 8,764, and Filipino alone or in combination at 1,415. Okay, now, we already provide ballots and sample ballots and other materials in Spanish and in Tagalog, which is South Pacific. So I would argue that the needs of these privileged voters is already being met. And you allowing them to bring in a cell phone that has super capabilities and surveillance capabilities and things, I think is a bad idea, not only in terms of my own privacy in a polling location, but I think there's an issue of security. I mean, you can't prove the system's not hackable. I would challenge you to do so. I would love you to do so, but I don't think you can. I don't think there's a will from the Secretary of State to do so. And so from a voter's confidence level thing, I'm against it, big time. Let me move on.
Mr. Williams, I just want to clarify also, though, that just to speak specifically to this proposed regulation, it does specifically address just registered voters with a physical disability as it relates to interpretive services. I know we had a commentary.
Limited English proficiency. Limited English proficiency. You're letting non-English speaking people, I made this comment in the workshop, if you want to create a system where you allow non-citizens to get into our system, this is part and parcel of that, okay? All right, you're making it so easy, and it's an unequal system. It's unfair. You may say, "Oh, we must give accommodations." No, it's called an unconstitutional enlargement of privileged rights. Okay, and it's not equally shared. It's against 13th, 14th Amendment, all sorts of goodies. All right? I'm not a lawyer, but there are problems here that I see on the constitutional grounds. Let me finish my comments. I'm almost done, Mark, and then you're welcome to pick it apart. All right? Okay. Excuse me, my nose is running. My allergies are really bad today for some reason. There are issues of privacy and enforcement, okay? And this is really where the regulation is non-specific. I mean, if you want to regulate how a poll worker is supposed to monitor somebody's cell phone use, it doesn't really give you any detail, does it? When do they call the cops? When do they seize the phone? And when are they obstructing that voter's right to vote? When are they illegally surveilling that voter? Like you said, they can't pry over the shoulder when they're accessing their sample ballot. And yet there's a requirement in this regulation that they need to do something similar to that. I mean, it's kind of vague. How do you monitor somebody from illegal use of their phone? You can't really, and it's an undue burden you're placing on the election worker who's busy processing people. I mean, you need somebody just dedicated to that security issue alone. And then, of course, what happens if they are using it improperly? There's no definition in this regulation to that. One last point to make. I think you're inviting a cybersecurity threat by allowing cell phones inside, and I believe that cell phones and other wireless connected devices should be banned from the polls. The county currently provides written instruction that negates the need for online sign language and so on. That's it. That's my comment, Mark. Thank you for putting up with me today.
Thank you for your comments, Mr. Williams.
There are no other callers choosing to participate at this time.
Thank you, Broadcasting. At this time, I will close public comment on proposed regulation R094-23. And hearing no further public comment, regulation LCB file number R094-23P is adopted with the changes as mentioned on the record and will move forward to the Legislative Commission. At this time, I will open the adoption hearing regarding proposed regulation R106-23. Existing law requires that with certain exceptions, each polling place must be accessible to a voter who is elderly or a voter with a disability and must include certain voting booths for use by such voters. Sections 1 and 11 of this regulation require county clerk and city clerk to confirm to the Secretary of State by a certain deadline that the polling places in the county or city will comply with such accessibility requirements. Existing regulations require the Secretary of State to send each county clerk a notice designating the offices for which candidates are to be nominated at a primary election and require each county clerk to publish the notice in a newspaper in his or her county within 10 days after its receipt. Section 2 of this regulation requires the county clerk to also publish with such a notice any county and municipal offices for which candidates are to be nominated at a primary election. Existing law and regulations require the county and city clerk to submit various plans to the Secretary of State relating to the conduct of an election. Sections 3, 4, 6, 8 to 10, 12, and 14 to 16 of this regulation, 1, authorize a county or city clerk to resubmit a previous plan if no changes are being made, and 2, require the Secretary of State to review the plan and notify the county or city clerk not later than 15 days after submission, whether the plan complies with certain requirements. Existing law provides that if the last day for filing any paper mentioned in the provisions of the Nevada revised statutes relating to elections falls on a legal holiday, the deadline is extended to the following business day at 5 p.m. Existing law further requires that a voter who voted by provisional ballot who failed to provide the required identification at the polling place or with his or her mail ballot present present his or her identification to the county or city clerk not later than 5 p.m. on the Friday following Election Day. Section 5 of this regulation provides that if the Friday following Election Day is a legal holiday, the deadline is extended until 5 p.m. on the next working day. Existing regulations require the county and city clerk to submit to the Secretary of State a list containing certain information for each ballot drop box listed in the county or city. Sections 7 and 13 of this regulation require the list to be submitted not later than 45 days before each election. Existing regulations require the county and city clerk to submit to the Secretary of State a plan relating to ballot drop boxes that are tampered with or rendered inaccessible. Sections 8 and 14 require the plan to be submitted not later than 90 days before each election. Now, I do want to clarify when it relates to proposed and really not just proposed regulation R106-23P, but all of the regulations, again, when we talk about a county clerk, that is synonymous with a registrar of voters, so this regulation does apply to registrars of voters in our two largest counties, of course. To make sure that was clear, Second, I do want to address also one of the concerns that was raised about 106. Really, again, these are existing plans, some of which did not have a specified due date. So we're really just providing clarity so that the public is aware of when those reports are due, as well as so that the county and city election officials, as applicable, understand and know when to turn those reports in as well. So it's not ambiguous. Other feedback that we received. Again, I do want to clarify that this does not change the requirements to cure a provisional ballot. If a voter does receive a provisional ballot and they are required to provide information to that county or city election official as applicable, this does not change or alter in any way, shape, or form those requirements. Simply allowing, this is simply extending in that case of that specific section, the time period to drop them off, so that if there's a holiday and the office is closed, that they are simply afforded an additional business day to drop off that information. Okay. At this time, I will open public comment on proposed regulation R106-23P. Starting here in Carson City, there's no one. In Las Vegas, there's no one. And then broadcasting, could you check the phones, please?
Yes, Chair. If you would like to provide public comment on R106-23P, please press star 9 now to take your place in the queue.
Good afternoon. This is Ellen Gifford. Mark Velashan, I don't know what happened. I wanted to speak about R094-23. I thought I had entered the correct information to be able to do that, but I wasn't called upon.
Ms.
Can I
Gifford,
do that
if you'd like
now,
to,
or
yes, ma'am. If you'd like to make comment on the previous regulation, for the record, we can certainly take it.
I appreciate that. Thank you so much.
Yes, ma'am.
NRS 293296 states that any registered voter who, by reason of a physical disability or an inability to read or write English, is unable to mark a ballot or use any voting device without assistance, is entitled to assistance from a consenting person of his or her own choice. I respectfully repeat, they are entitled to assistance from a consenting person of his or her own choice. There is no mention in that statute of assistance from a device. A device cannot consent, and the words consenting person can in no way be misconstrued to mean a device of any kind. I submit that LCB file number R094-23P contradicts and seeks to change an existing law, and that can only be done through a legislative session. Therefore, this proposed regulation cannot be adopted. Thank you very much.
Thank you, Ms. Gifford, for your comments.
If you have recently joined and you would like to provide public comment on R106-23P, please press star 9 now to take your place in the queue. There are no other callers choosing to participate at this time.
Thank you, broadcasting. At this time, and again, we are, just to clarify, we are still on the adoption hearing for proposed regulation R106-23. With no more public comment, we'll close public comment, and regulation LCB file number R106-23P is adopted and will move forward to the Legislative Commission. We'll now open the adoption hearing regarding proposed regulation R107-23P. Existing law requires the Secretary of State to adopt regulations related to the conduct of elections and provide that 1. General election laws, insofar as applicable, must also apply to a recall election, and 2. A recall election must be conducted pursuant to the provisions of primary city, general, and general city elections. Existing law and existing regulations require a county clerk and a city clerk to submit to the Secretary of State before certain elections plans relating to the conduct of the election. Sections 1 and 2 of this regulation provide that a plan required to be submitted to the Secretary of State before certain elections must also be submitted before a recall election, insofar as applicable, and must be submitted not more than 5 business days after the county or city clerk receives notification from the Secretary of State that the number of signatures on a petition to recall a public officer is sufficient. Sections 1 and 2 also require the Secretary of State to review each plan and notify the county or city clerk whether the plan complies with the applicable requirements. The feedback we received relating specifically to proposed regulation R107-23 primarily focused, again, on questions about its applicability, questions about its relevance and the number of times that recall petitions had been initiated across our state, and then also asked about, there were some concerns raised about the increasing bureaucracy, and instead recommending informal guidance. Again, this is one of the situations, as I mentioned previously, just to put the explanation on the record, relating to some of the recall petitions that have been discussed over the previous 12 to 48 months, and specifically those same plans that are required, again, tying it directly into the needs for increased security and transparency. The Secretary wants the public to understand that the same level of scrutiny, security, and transparency that is put on a general election in a presidential year, for example, be also applied to a recall election, even if it's a much smaller scope in a single jurisdiction or perhaps a single portion of a county. So this proposed regulation, again, simply identifies that those same plans are applicable, albeit not in a 90-day or 45-day prior to, given the timelines as identified in the Nevada Constitution and in NRS 306 and 293 for that matter, relating to recall petitions, but instead, again, an appropriate and realistic timeline so that, again, those documents can still be created. At this time, I will open up public comment on proposed regulation R107-23, starting here in Carson City. Seeing none. In Las Vegas, seeing none. Broadcasting, can you check the phones, please?
Yes, Chair. If you would like to provide public comment on R107-23P, please press star 9 now to take your place in the queue. There are no callers choosing to participate at this time.
Thank you, Broadcasting. Hearing no public comment on R107-23 is closed. And a regulation LCB file number R107-23P is adopted and will move forward to the Legislative Commission. Agenda item number 22, public comment on matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. Is anyone interested in providing public comment about a matter not on the agenda? Starting here in Carson City, I don't see any. In Las Vegas, there are none. Broadcasting, can you check the phones, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Chair, there are no other callers choosing to participate at this time.
Thank you, Broadcasting. This time we will close public comment on matters other than the previously listed LCB file numbers. As a reminder, the adoption hearing today is not the end of the regulations process. Following the completion of this adoption hearing, the next step will be a trip to the Legislative Commission later on this month on February 26th at 2 p.m. Additional information about the timing, location, and means to view or attend that meeting may be found on the Nevada Legislative website, which is leg or leg.state.nv.us. If you have any problems or other questions, please don't hesitate to contact the Elections Division at 775-684-5705 or via email at nvelect@sos.nv.gov. Excuse me. And then finally, again, as we conclude this adoption hearing, I do want to send a thanks to all the clerks and registrars who provided input to these regulations during this election cycle. As well as the members of the Secretary of State's staff across the agency and specifically in the Elections Division who contributed. And then finally, our colleagues at the Office of the Attorney General who also spent significant time and effort, and their dedication is absolutely worthy of note to make sure that these regulations were in line with the statutes and able to provide, again, essentially to meet the intent of the Secretary to increase security and transparency. Thank you all for your comments that were participating. I do appreciate that as well. That being said, this adoption hearing is adjourned. Thank you.